So I wanted to provide a deeper dive into the case that I was talking about that I got to argue in front of the Eighth Circuit Court of Appeals. So this is the Eighth Circuit, which means it's directly below the federal Supreme Court. And it was a really fun case because there's a lot of really sort of deep issues that are at play here. So the facts are that my client was a worker at the hospital. The hospital had a vaccine policy. After the hospital instituted the vaccine policy, the COVID policy came out from the federal government. The federal government's COVID policy required that all workers receive the vaccine unless they qualify for an exemption. And our claim is that our client, when she requested a religious exemption, that they didn't give her a meaningful review process and that this infringes upon her civil liberties. Now, in the context of this case, the established law in the Eighth Circuit, it relies heavily on this case that's called Laboon. And the Laboon case was actually a Third Circuit opinion that establishes a very bright line rule about when you can sue somebody under Title VII for religious discrimination. Title VII is the statute that empowers people to file suits for discrimination of many types under the federal law. And the Title VII prohibition on discrimination on the basis of religion was part of what my client sued under. And it was also under the provision of the statute that prevents an employer from retaliating against you for trying to exercise your religious freedom rights. Now, the state of the Supreme Court's jurisprudence on this in the recent times has been changed dramatically. So I was saying before there was this prior test called Laboon. And in the Laboon test, they're looking at whether or not the organization was religious. And if it's religious, they say that organization is allowed to discriminate on the basis of religion. So if an employer qualifies under the specific statutory exemption contained in the Title VII statute, such that they are a religious organization, then you can't sue them for religious discrimination. And under the old test, this Laboon test, it was very difficult to show that an entity like a hospital would not qualify if they had some connection with the Catholic Church. So we all know that there are these large hospitals that originally were entirely run perhaps by the Catholic Church, but that now have a largely secular role in terms of providing healthcare to people. And it very well may be the case that these hospitals are doing the work of God from their perspective, and there's no dispute that it's a good thing to provide this healthcare. But the question in this case was about balancing their right to be a religious employer versus my own client's rights to exercise her deeply felt commitments to certain religious beliefs. Now, the Supreme Court's case in the recent Guadalupe case, they made it very clear that it was not the job of the court to investigate the sincerity of somebody's beliefs. So if somebody has a sincere religious belief that the law is evolving to be very protective of those sincerely held religious beliefs. But how this interacts with the determination as to whether or not an employer qualifies as a religious employer is significantly more complicated, because the command of the Guadalupe case was we cannot investigate whether or not an employer is religious to begin with, because doing so would violate the First Amendment's prohibition on the government becoming excessively entangled essentially with religion. So when we were arguing this, the defense lawyer's entire position was based on this Laboon case. And it was super surprising to me, honestly, but it was awesome because the judges immediately were like, they think that the case is nonsense, or at least that they think that, or at least one of the judges said that. And it's because the standard under Laboon is just so difficult to overcome in terms of whether somebody's religious. One of the examples we talked about with the Court of Appeals was, well, what if you have a company that sells religious memorabilia? So you have like a Temu or some kind of web store located in the United States, And their entire purpose is to sell like Jesus candles and crosses and statues of Buddha and all this kind of religious iconography. But the company is totally for profit. At that point, how are we supposed to look at them? Are they a religious employer or are they not? Now, the legislative notes that were, in fact, argued about when the Third Circuit adopted Laboon and that somewhat play into this, there was a discussion when the statute was passed that the legislature didn't want this exemption to extend to all organizations that were affiliated in any way with religion, because, of course, that would be quite a lot of organizations. And so the discernment prior to Laboon was like, well, if they're a religious organization, and that means that they're all co-religionists, so no other people of other faiths are allowed to be there, then maybe they should have this sort of immunity from these religious lawsuits. Because if you go to work for, say, a Catholic school, for instance, then it may be fair for them to say, well, if you don't believe in Catholicism, you can't work here. And that's discriminatory on the basis of religion, but it's exempted from the applicability of the statute. It becomes more complicated, though, in these cases involving hospitals like we had here. Now, there's a present pending Supreme Court case. In this case, it's Catholic Charities Bureau versus Wisconsin Labor and Industry Review Commission. And this case is presently on the Supreme Court's docket. And it has the question of whether or not the Wisconsin government is permitted to tax this organization in a particular way, and whether Wisconsin can pick and choose whether religious groups are going to be taxed on the basis of their self-professed organizational status as a religious institution, or in the alternative, if the organization, there's some sort of meting out, like the government has to look at the actual characteristics of the organization to determine if it's predominantly religious in nature. So the Wisconsin case, the Wisconsin government was trying to say, this Catholic charity is not religious. We're not going to tax them as being religious. And the Catholic Church, is saying, well, under the Guadalupe case, you can't, as the government, make a discernment as to whether or not my group is religious or not. You can't investigate my beliefs other than to accept that they're closely held, sincerely believed. And so this case was referenced by one of the judges in saying, it seemed to me clear that the Court of Appeals doesn't like this Laboon test because it seems to excessively engage the court in discerning whether or not the organization is religious. And it's basically patently unfair because, it's like, well, what about my client's religious beliefs? Does she have to abandon her closely held beliefs if she's working at a hospital that happens to be owned by a religion in the context of a nationwide government mandate that all healthcare workers receive this vaccine? So it seems like they want to get rid of this Laboon test, but the question is like, what's going to come next? And this Supreme Court case about this tax stuff is going to be super interesting and maybe dispositive about this issue because it should define how the courts, what the courts are allowed to review and what the government is allowed to review when it's making these types of classifications. And my guess, or like what I think if I was the ruler, what it would be, well, if they are running this organization and they require everyone that works there to be part of this religion, then they should be allowed to discriminate on the basis of religion. If they're not, then they shouldn't. And basically that, particularly if the role is like a lay role, you don't need to be a co-religionist to do the job, and you're not being evaluated on the basis of anything other than the performance of this purely secular function, that you shouldn't be insulated from this suit. But equally so, the Guadalupe case seems to suggest that they can't at all investigate this type of question except by taking a very particular route through it. And this Catholic Church case is very interesting and is going to show about what the implications would be in the event that the Catholic Church is able to get this immunity from taxation on the basis of their self-professed status as a religious group as to these particular charities or, purported charities. And I think it's, basically a battleground for the First Amendment for the next 10 years. And we're excited to see what they do. So I hope my client wins. I'm going to print in the description a very detailed article about this and examining all of the cases that have dealt with this topic in the past 10 years. So if anybody wants to review that, go ahead and do so. And that's it. Thank you. Bye-bye.